strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may and usually are relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to service plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you.
The specific words that the judge used for the ruling is very important. That's why I wanted to show you that video. Translation: the jury can infer that Adam Waldman made that statement on behalf of Johnny Depp, but they have to determine that it's false and made with actual malice. Follow me for more.